Hi everyone, I'm Chital, Senior Support Team Member. Today I'm going to do a webinar on responsibilities of Company Director under Corporation Act 2001. Before we begin, I would like to bring to your notice that if you have any questions, you may type your questions below and I will answer them at the end of the webinar. I have uploaded handouts so you can download it and save it on your system if you want. In this webinar, we will discuss what are the responsibilities of the directors under Corporation Act and how a director can protect their assets. Many people believe that the directors of the company are owners of the company. However, it is not true. In fact, the directors are not the owners of the company. They are elected by shareholders to manage the company on their behalf. Directors are therefore required to comply with basic responsibilities and duties under the Corporation Act, which is in the interest of the company and stakeholder. So what are the sources for directors' responsibilities and duties? Or where does the director's responsibilities arise? The law that governs the director's responsibilities are Corporation Act, Company's Constitution, and Common Law. We will have a brief sneak peek in these resources. First is Corporation Act 2001. Chapter 2D of the Corporation Act provides statutory duties of directors which directors are expected to comply with. These duties include duties of care and diligence, duty of good faith, duty not to make improper use of position and information, and duty not to trade when company is insolvent. We will discuss these duties in brief later. The second source is Company Constitution. Company's internal management may be governed by replaceable rules, by a constitution, or a combination of both. So what is a constitution or replaceable rules? For the ones who are not aware, let me explain that the constitution and replaceable rules has the effect of a contract between the company and each director and secretary, under which each agrees to observe and adhere to the constitution and rules. Company's constitution can specifically provide guidance on the director's duties. The last is the common law, which refers to the law made by judges in various cases. Some duties emerged from various cases include duty to act bona fide in the interest of the company, duty not to act for an improper purpose, duty to retain discretion, and duty to avoid conflicts of interest. So why is it important for directors to comply with statutory responsibility? When director complies with their statutory responsibilities and duties, apart from reducing their liability, it also helps them to promote good corporate governance, ensure that directors act in the interest of the company, and assure that directors are putting the company's interest ahead of their own. The basic objective for this statutory responsibility is to enhance stakeholder confidence in the working of the company and enhance corporate image. So we move to the next slide. So what are the responsibility of a director towards stakeholder, or what does Corporation Act requires from a company director? We will have answer to these questions in next slides, which will highlight directors' main responsibilities. Section 180 subsection 1 provides that the director of a company must exercise their powers and discharge their duties with the degree of care and diligence that a reasonable person would exercise if they were a director of the company and would act in those circumstances. So a director is expected to exercise degree of care and diligence and act in a situation in the same way as a reasonable person would exercise in that situation. Section 180 of the Corporation Act also provides for business judgment rule. Business judgment basically means any decision to take action or not to take action in the best interest of the company in respect of any matter relevant to the company's business. So director has responsibility to judge which action would be in the best interest of the company. There are 4 important checklists to keep in mind for applying business judgment rule. They are: first, to make judgment in good faith and for proper purpose. If the purpose is improper or not in good faith, there is a breach of duty. Secondly, there should not be presence of any material personal interest while making the judgment. So director should not make judgment. I'm sorry for this. Yeah. So the director should not make judgment on the basis of their personal interest. If they do so, there will be a breach of duty and directors will face dire consequences. Third is director must have knowledge about subject matter to the extent they believe to be appropriate for taking the judgment. Before taking any judgment on any matter, director should have reasonable knowledge about the matter which will help them to make appropriate decision. Having insufficient knowledge is not defense for breach of duty. Lastly, judgment should be in the interest of the company. I'll cite an example here which will help you to understand this section. If a director receives a balance sheet, it is director's responsibility to question information put before them to ensure that it is truly representative of the company's position and not just accept what may be put to them by the employees. Directors cannot escape their liability by delegating their responsibility. There will be a breach of directors' duty of care and diligence if directors do not authenticate the accuracy of the balance sheet put forth before them. So, directors should always be vigilant and act in the best interest of the company. Section 181 of the Corporation Act provides that the director of the company must exercise their powers and discharge their duties in good faith and in the best interest of the company and for proper purpose. To evaluate whether the director has acted in good faith, there is a test of honesty. This test is subjective and varies according to individual circumstances. There will be a breach of duty if directors fail to give proper consideration to the company's interest. For example, if a company's interest is same as director's interest, the director must prioritize company's interest than his interest. There is an exception to it. If a director fails to consider the company's interest, but the transaction is in fact for the benefit of the company, there will be no breach of duty. A director must therefore act honestly at all times despite any other conflicting duties. There is a breach of duty where director acts honestly but for an improper purpose. So what is improper purpose? Improper purpose is an act of director which is outside the scope of his powers granted by the company's constitution or by laws. So both the criteria of good faith and proper purpose are required to be met to escape the breach of duty under this section. In the Adler's case, Rodney Adler was a sole director of subsidiary of HIH which made a payment of $10 million to acquire shares by way of trust. This transaction did not have board or members' approval, nor there were any proper disclosure and loan documentation. The court found Adler to be guilty of breach of duty under section 180 and 181. Section 182 provides that director of a company must not improperly use their position to gain an advantage for themselves or someone else or cause detriment or damage to the company. There is a breach of director's duty if director acts with intention for obtaining any advantage or causing damage to the company, regardless of whether the benefit or damage actually occurred. So even an action with an intention to gain advantage or cause damage to the company will result in breach of duty and result in severe consequences. Section 183 of the Corporation Act provides that directors must not make improper use of the information for gaining advantage for themselves or someone else or cause damage to the company. This section is more or less same as the earlier section. The only difference being earlier section talks about the improper use of position, while this section talks about the improper use of information. So if a director possesses any information which he acquires due to his position and misuses that information for his benefit or for causing damage to the company, it will result in breach of director's duty. There is, however, an exception to this rule. While promoting the interest of the company, directors may indirectly promote their own interest. For example, a director of a company, say ABC Limited, is paid on basis of company's performance. The directors authorizes a transaction with another company, say XYZ Limited, which is in the best interest of ABC and will increase the company's performance and eventually increasing the company's remuneration. The director has indirectly promoted their interest while promoting the interest of the company. In this scenario, there is no breach of duty because the director had in mind to act in the best interest of the company. There is a case of Wizard where Wizard was director of Telstra and acquired confidential information due to his position as director. He used this information for his own benefit by indulging in purchase and sale of shares of the company. The court found Wizard guilty of breach of his duty under Section 183 and ordered pecuniary penalties and passed disqualification order against Wizard. Section 588G provides that it is director's duty not to trade while company is insolvent. A person breaches his duty when all the mentioned four conditions are met. The first one is that the person was director of the company at the time when company incurs a debt. The company is already insolvent at the time or becomes insolvent by incurring that debt. Director was aware at that time, or a reasonable person would be expected to be aware in a like position and situation that there are reasonable grounds to suspect that company was insolvent or would become insolvent, and director failed to prevent the company from incurring the debt. So, a director will breach his duty if he is a director of the company when company incurs a debt which results in company becoming insolvent and director does not prevent insolvent trading. So, in such scenario, director would breach his duty. Insolvent trading is a situation when director can be personally liable. When a director allows a company to trade when the company is insolvent, the directors who allow the company to incur liabilities after being insolvent may become personally liable for the company's debt incurred after that point. So directors have to be very careful and analyze that the company does not trade when it is insolvent. Tips and tricks to prevent directors' liability. We saw earlier that insolvent trading can make director personally liable for the debts incurred by the company, but there are certain defenses available to directors under Section 588H to prevent this liability. These defenses are: the first defense is that the director believed that the company was solvent at the time of incurring debt and would remain solvent even if debt was incurred. The second defense is that the director believed that a competent and reliable subordinate was monitoring the company's solvency position and keeping the director informed. The third defense is that when the debt was incurred, the director did not take part in management of the company because of his illness or for some other good reason. The fourth defense is that the director took all reasonable steps to prevent the company from incurring the debt. So, in the mentioned four scenarios, directors can defend themselves from being liable for insolvent trading. There are severe consequences for breach of director's duty. The penalty consists of criminal offense penalty and civil penalty. First of all, we will understand what is a criminal offense. The criminal offense under Section 184 of Corporation Act includes when a director commits an offense recklessly or intentionally dishonest and fail to discharge their duties in good faith and in the best interest of the company or for a proper purpose. Second will be when a director commits an offense if they use this position with intentional dishonesty or recklessly in order to directly or indirectly gain an advantage for themselves or someone else or cause damage to the company. Third is when a director obtains information because their position misuses it with the intentional dishonesty or recklessly in order to directly or indirectly gain an advantage for themselves or someone else or causing damage to the company. A director may also commit a criminal offense for failure to prevent the company trading while insolvent. The maximum penalty for criminal offense in relation to director's duty under the Corporation Act is fine of $200,000 or 5 years imprisonment or both. Civil penalty includes up to $200,000 or compensation to company for any damage caused due to director's breach of duty and or disqualification of the director from managing company. In Adler's case, Adler was disqualified from managing company for 10 years. So this is the end of our webinar today. If you have any questions, you can write down on your screen and I will reply them. Are there any questions? Alright, so I'll conclude the webinar now. Thank you. Bye.